Yes, Mr. Thomas.
Good morning, my lords. If I could just pick up with 1 or 2 points left over from yesterday, really. The first is the discussion we had in relation to whether or not Section 45 ever offered a disregard, where the AB transaction and the ABC transaction was the transfer of, say, a freehold, and the BC transaction was the grant of a lease. Assuming even that the lease was a lease at no premium, but it doesn't really matter. And the answer on reflection was no, it never was. I don't think this was ever the position of the revenue, and I think the revenue indicated that yesterday. And when trying to find out precisely why it is that it was not, it isn't as clear as it might be, but certainly in my respectful submission there may be some things to be gained from the legislation. If one goes back to page 1061, which is section 45, the substantive bit of 45 at the top. And one looks at section 45 1b to see exactly what was the transfer of rights.
Yes.
It has to be an assignment, subsale, or other transaction relating to the whole or part of the subject matter of the original contract. Yeah. And I think that was probably the fundamental bit.
Because landlords do think leases are a sort of slice out of a freehold cake.
Well, yeah, well, if one were to take that view, then one might say that it did relate to the subject matter. But
well, and also that it's part. It's part of.
It is part of in that it diminishes the estate that one might have. But certainly from, we would say that nobody at the relevant time ever saw this as having that particular effect. No. And it's unlikely that the draftsman saw that it had that particular effect. And if it had been intended to have that particular effect, one would have assumed that there would have been somewhat more sophisticated computation provisions for determining how you actually work out what fraction of each of the two interests is then to pick up a tax charge, because you've got to do that, because both continue to exist. It's not a pure subsale where nothing exists after that. There is still something which has been retained.
So the critical difference is that there isn't a merely momentary transfer under the completion of the original contract.
The intermediary ends up with something which really continues to exist and may be very substantial in value.
Yeah, and it's going to vary.
Of course,
hugely from case to case, isn't it?
Yeah.
You know, the length of the lease, whether there was a premium or not, and
one can envisage hard cases, but the question is whether or not one ought to take the hard case of somebody who receives a freehold and then grants a 999-year lease at a very substantial premium, almost equal to the price he's just paid, and say, well, terribly sorry, but you didn't need to do it that way. You should have assigned the freehold.
It may be irrelevant. Before the 2003 Act, the tax was payable on documents only, so that in that kind of situation you might, I suppose, have both a conveyance of the freehold and a lease.
There would have been, indeed.
Ordinarily, you would have.
You would have. Yeah, I mean,
unless either or
it was a very small lease.
One or the other was left in contract only.
Yes.
I can't recall how long leases were taxed under the old regime.
There was a lease premium charge, and there was also a charge on the rent by reference to the It was a fractional computation.
So a 999-year lease at a premium almost equivalent to the price of the freehold and a ground rent. Would it be double taxed? There must have been some relief.
Not necessarily. Okay. Not necessarily. I'm afraid one of those things one always finds in tax is there are hard cases where one would like to give relief, but I'm afraid it's just not there.
Yeah. Well, forget the historical question. It's not going to help.
No.
Definitely not.
So the answer, I think, from both sides is you simply wouldn't have got there. It therefore follows from that if one adopts that policy and analysis, that you could not in section 71A have thrown up the sort of structure that was being attacked by the amendment in April 2005 to 45.3. Because the point of section 73 was to avoid the restrictions of the section 73.2 relief by substituting 45.3 disregard. And in this sort of case, the corresponding transaction would have been the transfer to the financial institution, followed by the grant of the lease down. And the argument would be that the financial institution doesn't have to pay SDLT because it can rely on the disregard, and then the lease would then be protected under 71A3 in the same way as the 73.3 position. I mean, if that hadn't been the case, and assuming for the moment that in fact section 45 does make provision for a subsale into a lease structure, then one has to ask, well, if that were so, how would the Parliament have gone wrong in drafting the amendment to the tailpiece of section 45.3 in April 2005? And what would it have been intended to do in order to put 71A and 72 into precisely the same position as 73? And the answer in my submission is that it would have done exactly the same as it did in the tailpiece to 45.3 as it stood before 2011, but it would have included the words, apologies, just try and bring it up. So, except in the case where the secondary contract gives rise to a transaction that is exempt from charge by virtue of section 71A3
Yes.
or 72A3 or 73.3.
Yes.
It wouldn't have done what was done in 2011.
No. And indeed, they actually changed the 73 part by crossing out the sub 3.
Yes.
Yes.
So Parliament is, of course, entitled to have second thoughts, and that's what happened in 2011, it has a second thought. But what one can't, in my respectful submission, derive from that is that by some magical waving of the Inco wand, one ends up in a position that one can now do for Parliament what Parliament thought it ought to have done in 2011, and assume that it would have done that in 2005. So that's why there isn't that addition of those words. First, because it wasn't thought that there was any need, because one didn't have the same sort of opportunity in relation to 71A2 as one had in relation to 73.2 to replace the relief by the disregard. And secondly, that even if that hadn't been the case, one would still have ended up in a position that the amendment to 45.3 would not have done anything which would have affected this particular case. Because even if this had been an opportunity available to parties in 2007, 2008, when these transactions took place, the trick that was being knocked on the head by the 2005 restriction was the avoidance of the need to make a claim under 71A2, and that just doesn't happen here. The problem here is that you have the section 45.3 disregard, followed, it is said by the revenue, by an entitlement to a claim under 71A2, and then a further claim under 71A3. So it's not the same sort of case at all. So that's that. The second point is I said that I was going to take certain provisions in the Act which talked about payable, made it perfectly clear that you could have something which was payable before you got to a self-assessment, to the land transaction return. And the first provision of that is at page 1083.
Page?
1083.
1083, thank you.
Which is a section to which we will have to return when I get to my what is the actual consideration point. But the way in which the legislation works, putting it in broad brush terms at the moment, is that section 51 tells you that where you have to impose a tax charge on a transaction, a land transaction taking place, but some of the consideration is either contingent or uncertain or otherwise incapable of being computed. There are a number of different strands, but effectively what the legislation does at that stage is to make you pay the maximum that might be payable, come what may. So if a contingency would lead to a further sum being payable, then the assumption is made that that sum is payable until it proves at a later stage that it wasn't payable.
You get a refund.
When you get a refund. And that was to knock on ahead the contingency principle structure under stamp duty, which allowed you to avoid stamp duty on anything which was actually contingently payable, but not otherwise payable. So they bring those into charge into Section 51. But Section 51 is made subject to Section 80. And then when one gets to Section 80, one sees how it works out at a later stage when the uncertainty becomes certain, or the contingency either happens or does not happen. So where Section 51 applies in relation to a transaction, and in the case of contingent consideration, the contingency occurs or it becomes clear it will not occur, or in the case of uncertain or unascertained consideration, amount relevant to the calculation and consideration becomes ascertained, the following provisions have effect to require or permit reconsideration of how this part applies in the transaction and to any transaction to which is linked. And then it says this, and this is the point which is relevant for the present purposes. If the effect of the new information is that a transaction becomes notifiable, and by that they mean, if as a result of the event in question, the amount of consideration that is chargeable consideration increases above the threshold at which you have to make a land transaction return for the first time. Because some transactions, as we will see, are not notifiable because they're just too low or they get a relief or whatever and they don't have to have a return made. All that additional tax is payable in respect of a transaction, or that tax is payable was when no tax was payable before, then within 30 days the purchaser must make a land transaction return. So it's not a case of tax only become payable when a land transaction return has been made. Here, a land transaction return has to be made because tax is payable. And this is, in my submission, in a sense, the new language which follows from self-assessment. In the old days, of which Whitney was an example, you earned money, the inspector might have asked for a return from you, but the inspector raised the assessment. And when he made his assessment, you worked out all the various different elements. You ended up with a net figure which was the payable figure. But until the assessment had been made, nothing was payable because you hadn't been in receipt of an assessment. That's all gone. We're now in a new world where self-assessment reigns almost entirely. And in circumstances like that, and especially in a simple tax like SDLT, and I say it's simple not because of the statutory language, but simply because, yes, when you make a land transaction, an amount is generated and you pay tax of 4% on that amount, or 5%, or whatever it might be in future. But you know what it is. So you can compute the tax without any difficulty whatsoever, and you can say, I have sold a piece of land, and I have bought a piece of land for £1 million. The tax payable is therefore 4% of £1 million. And that's what the legislation says. So it's also dealing in Section 80 where you have a case where the amount of consideration that was chargeable was not clear at the outset because it might have been a function of profits or whatever. And the profits are then ascertained. You now know what it is. And you hadn't filed a land transaction return before because you thought there wasn't, in fact, going to be enough payment to be made to come above the threshold. But you now know that the amount of chargeable consideration is 200,000 and you have to make a land transaction return. But what the section says is, well, tax is now payable. And
when do you actually have to pay?
you have to pay within 30 days in this particular case.
Of your return?
No, you have to file a return and you have to make payment, but they're two separate events.
Quite. So what triggers the payment? Is it an assessment?
No,
No,
you pay. I mean, in the good old days, you sent your land transaction return and you sent a check in with it.
Yes.
You now file land transaction returns electronically, so you send the money in separately. But you do the computation, you pay the tax, you send the cheque off to the revenue or electronic
Bank
transfer.
transfer.
And if the revenue disputes it or says you've, for example, declared that PBL is the purchaser when it isn't, or the vendor rather when it isn't, and that the exemption works on that basis, what does the revenue do to query it?
They open an inquiry under Schedule 10.
Has to be an inquiry, does it?
Yes.
If you have filed a return, they open an inquiry. If you haven't filed a return in relation to the relevant land transaction, they can issue a notice of determination. Or if nothing happens and time goes by, they can make an assessment. They've got a number of different processes which can be used, but they're all in Schedule 10. And the concept in Schedule 10 of inquiring into transactions and chargeability and raising and collecting tax is all concerned with the less than diligent taxpayer. It's not concerned with the diligent taxpayer who undertakes a transaction, realizes that tax is payable, pays the tax and files a return. And that is why when one reaches...
In the present case, you had 2 nil returns, didn't you, from the only 2 possible taxpayers?
You also file returns sometimes when you have to claim a relief, because you may have to
I
claim a relief.
understand that.
Yes.
But that was the effect.
Yes.
Whether you call it lack of diligence or honest error or anything else, it doesn't matter. The effect is that you have 2 nil returns.
Indeed.
What do you say the revenue can or should do, faced with unanimity amongst the only 2 relevant parties?
They inquire.
They should have opened an inquiry
Absolutely.
and assessed both of you, I suppose.
Well, they have a choice. And my understanding is, and I only glean this understanding from the submissions that were made in support of the application for permission to appeal in this case, that there were lots of other cases out there of a rather nefarious nature involving less reputable financial institutions possibly, where the revenue took the step, as I understand it, of opening inquiries into all the returns and either leaving the inquiries open into all the returns or then amending all the returns and putting the tax in every single one of the returns. Mm-hmm. If you can't work out what it is, then maybe you hedge your bets as the revenue and say, well, we'll meet you in court. But the revenue are not powerless in this regard.
Okay, thank you very much.
And Section 80 is by no means the only section. One sees similar things in Section 80, 81A, 86, I think, and so on. And in my submission, payable in this context is used simply to identify the sum which the transaction having undertaken is due to be paid by the taxpayer in accordance with the rules of the STLT code.
So it's identifying a liability.
It identifies a liability. And that was the view of the Court of Appeal, and the relevant passages in the Court of Appeal, I don't propose to take you to them, are at paragraph 35 of Lord Justice Patton's judgment and paragraph 52 of the judgment of Lord Justice Lewison. That's if your Lordship wants to go to it, it's page 279 of the second core bundle. It's at the foot of paragraph 35, he says, Mr. Gammy says, even if this is correct, the argument does not assist BBL on, because SDLT on 1.25 billion was not payable by MAR, given the inquiry into its land transaction return is now closed. I do not accept that argument. It seems to me payable must be payable on completion of the transaction which gives rise to the charge. The availability of relief cannot depend on how the claim for relief is subsequently determined or dealt with by the revenue. And similarly, as I say, 52 Lord Justice Lewison, picking up the point at the top of the page, The answers to why there was no SDL payable, there were two answers. First, given by Ms. Thomas, is that the question must be judged at the date of the notional transaction, whose effective date under 75A6 is the date of the last of the scheme transactions. That was long before the Commissioners issued the closure notice, with the result the closure notice must be irrelevant. Second is that it doesn't have a single meaning. It may mean due for payment or accruing due or liable to pay. And in the context of 75A1C, I consider it means liable to pay, as that expression is used in section 85(1). And I do not consider the mistake by the Commissioners in issuing a closure notice to one taxpayer can of itself impose liability on a different taxpayer if that is the reason why 71(1)(c) is engaged. That should be 75A1C. Just so, I say, my lord. And I went through yesterday and I explained to you that the problem that was faced by a potential P in trying to work out whether or not he had to file a return, if he had to file a return, and not being in a position to do that unless he was able to work out whether or not the tax payable under the notional land transaction matched off against the tax payable under the scheme transactions as undertaken. So that is in my submission all there is in the payable point, and I say there's nothing in it. And because in this particular case, on this particular analysis, MAR was indeed liable to pay £50 million SDLT to the revenue, when one undertook the computation whether one was looking at MAR being PBL or MAR being P or PBL being P, the same result arises that the section is not engaged. And that is hardly surprising because whatever else one thinks about the section is there as a backstop. It's intended to catch cases where even the revenue would say this, the ordinary collection machinery and taxing machinery and the provisions within the ordinary SDLT code imposing tax charges don't give a result which is an appropriate result, whatever that might mean. And if, therefore, one finds that the ordinary charging provision already throws up exactly the right amount of tax, why should we bother with the complexities of 75A1C? And my response to my learned friend's reference to Cotter is simply that Cotter is a case which is dealing, first of all, with the provisions of the Taxes Management Act, which are far more complex. Secondly, it's dealing with income tax and corporation tax, which have all these different adjustments to be made between them before one arrives having set everything out in a return with a net sum, which then becomes a sum payable. That just doesn't work for SDLT.
In the TMA, you don't get to payable until you've got through chargeable.
No.
And so Section 8,
Yes.
1AA,
Yes.
has a statutory definition.
Yes.
So income tax can't assist.
No. Thank you, my lord. So we say that since MAR was liable for tax under Section 44, 75A could never have been engaged. And therefore, for that reason, the Court of Appeal was right. And the Revenues Appeal, therefore, on that basis, to be dismissed because there's nothing left into it. But of course, I have all the other supplementary issues which I have to deal with on the assumption that my lady or your lordship should find between you that, in fact, MI was not liable to tax under 71A2 and made a proper claim for relief. So one then gets to the next question, which is whether 75A7 means that PBL must be P, because MAR is protected whilst PBL is not. And this is the submission that was made by my learned friend, that when one went through the process of interpretation of identification of P, there are a number of different reasons why MAR could not be P. And leaving aside the fact of, that we've already escaped, it was fundamentally that when one did the computations in 75A, MAR was protected either by 75A7 or because when one applied the rules, 75A1C did not apply to it. And there are two arguments, two lines of arguments here. The first argument by my learned friend was, well, 75A1C might be engaged in relation to PBL, but it's not engaged in relation to MAR. And the reason he said that was because he said you test this by using the taxpayer's approach, the sequential approach, because that's effectively what the Court of Appeal did. You go down the line until you find somebody who has acquired a chargeable interest and stop there, and then you test whether or not that person, as regards that person, one can say that the sum of amounts of SDLT chargeable under the ordinary tax code are less or not less than the amount which would be chargeable under the notional land transaction. And my first submission is that actually it's not quite what the Court of Appeal did in any event. What the Court of Appeal did, or what Lord Justice Patten in particular did, and this is pages 279 to 280 again, and it's paragraphs 40 to 44, was he said what one does is to focus on the subject matter of the notional land transaction, and that's the freehold. And if you find someone in the chain, as he called it, the scheme of transactions, who has acquired that interest, then there's no need to go on and worry about interests which are derived from that interest. And that, in my submission, pausing there, looking at it generally, has significant merit because it is the transaction which then most closely matches the notional land transaction, so the answers are likely to be similar. And it's only if the person who has the chargeable interest which is disposed of by V is not in that chain that one looks around for somebody else who has a chargeable interest which is derived from it. The sequential approach operates in a similar but not identical way, because what it does is it looks to the chargeable interest disposed of by V, and then goes down the chain until one finds the first person who has acquired the chargeable interest or a chargeable interest derived from it who's in the chain, and then tests that person and sees whether or not the conditions of 75A are satisfied as regards that person. And if only then it turns out that for some reason that person's identity of P doesn't make sense because the section is not engaged as regards that person, does one move on to somebody else who might thereafter have acquired the chargeable interest from that person. And it's just, in a sense, a logical way. If A acquires, I mean, taking a simple example, if A acquires a freehold interest from a third party on the 1st of January 2008, and on the 31st of January 2008, B acquires the interest from A, it makes sense to test whether or not A has got to make a land transaction return in relation to its ordinary acquisition, or whether it has to make a land transaction return in relation to the notional land transaction, and then only if A does not satisfy the conditions of P, does one move on to B and ask whether or not B is in that boat instead. But the Court of Appeal took a much simpler view. They said, well, let's have no preconceptions about anything. Let's assume that what we're trying to do is to identify the charge which relates to this notional disposal. Is there an actual disposal which matches up against the notional disposal, being the passing of the freehold interest on to somebody else? So yes, there is. In those circumstances, what's the point in going on and looking at the chargeable interest derived from that in order to charge that person instead? Another way of testing this would be to say, well, it's likely, though it's not always necessarily going to be the case, that the person who's acquired that chargeable interest is also the person who's got the valuable interest. If, for example, as was the case here, a lease is granted at a very substantial rate, it's unlikely that there's any capital value in the lease. All the capital value is going to sit with the freeholder. Here, the total rent payable under the lease over the 999 years would have been something in the region, I think, of £16 billion. So it's unlikely in those circumstances that if one were trying to sell that lease, it would have attracted much value in the open market. And my learned friend and I are both agreed that so far as the MOD to PBL transfer of the freehold interest is concerned, that cannot attract a charge under Section 75A because it simply doesn't involve PBL acquiring a chargeable interest because of 45.3 and DV3. So the first person and the only person in this particular chain of schemes, transactions, who ever acquired the freehold from V was MAR. Now, my learned friend's next step in his analysis, in his argument, is to say, well, even if one has arrived at MAR and one is looking at MAR and MAR's acquisition of the freehold, one finds that 75A1C is not satisfied at this stage because, he says, the PBL-MAR transaction is not exempt under 71A3, so that MAR is liable for SDLT under 1.25 billion. It means 71A2, but he's arguing that it's not liable, he's not entitled to the exemption under 71A2, even though the predicate to this particular part of the case is that MAR has no liability to tax because it's protected by 71A2. We wouldn't be here otherwise because we would have been back into MAR and payable territory. But here we have a scenario where we assume that MAR was entitled to the benefit of the relief under 71A2. We find that MAR has acquired the chargeable interest, the freehold, under a transaction where it's acquired that from PBL. And you then say, but MAR is not entitled to the relief. And the reason you say that MAR is not entitled, or the learned friend says that MAR is not entitled to the relief, is because you disregard the transactions which take place afterwards, which are the lease to PBL and the cross options. And therefore, because those, you have to somehow assume that those provisions, those transactions don't exist. That means that the conditions for 71A2 are now no longer satisfied. That, in my respectful submission, it doesn't make sense. You can't stop a transaction in that way, identify P and assume that no event which takes place after P's acquisition can be a scheme transaction for the purposes of 75A1C. And we know that because 75A2D tells us that scheme transactions include transactions which take place after the acquisition of the chargeable interest. And as it happens, it's wrong as a matter of law as well. And it's wrong as a matter of law because if one goes back to 71A1, one sees that the manner in which 71A1 operates, what I've called the narrative, and that's 1075. Says this section applies where arrangements are entered into between a person and a financial institution under which the things are going to happen. So one's looking at a bundle of arrangements. A better description of scheme transaction is hard to imagine. In order to get the relief, one has to have the arrangements in place. And those arrangements were inevitably in place. There was no way that MAR was ever going to be allowed to acquire the freehold in Chelsea Barracks if it hadn't 3 days before, on the 28th of January 2008, agreed to grant a lease to PBL and agreed as part of the understanding that whole Bible of documents that would have been entered into at that time, that the cross options would have been granted. So the arrangements were already in place. Those were scheme transactions. They were critical elements of the total package as far as MAR was concerned. And there was no way that one can therefore disregard them and say that speculatively one can treat this, therefore, as being an occasion on which you can pretend that although it was entitled to relief, it wasn't entitled to relief in order to get one off the Section 75A1 hook. And that is what my learned friend's argument amounts to, that one hypothesizes an impossibility in order to deny that the section operates as regards MAR. And we therefore say, well, 75A applied if 75A1, if we take the view that 75A was applicable in this case, then there was no reason why MAR should not be P, because 75A1C applied as much to MAR as it did to anybody else. And the second argument is that 75A7 applies in relation to MAR's acquisition, but doesn't apply in relation to PBL's acquisition. And your Ladyship will remember that 75A7 provides that the section is not to apply where subsection 1C is satisfied only by reason of sections 71A to 73 or a provision Schedule 9, which is all about staircasing, rents and so on. Whatever the technical analysis of the subsection is, one has to look to see in relation to each P what the relevant scheme transactions are and what the results of the STLT code was as regards those scheme transactions. And when one looks at what the scheme transactions are, and this is so whether one is looking at MAR or PBL, the minimum number of scheme transactions that had to exist in order for the notional land transaction to operate, in order for section 75A1 to operate, there had to have been a transfer of the chargeable interest from the MOD to MAR. So the transactions which led to that, which were then to be considered as whether they'd been subject to STLT or not, were first of all the transfer from MOD to PBL, which attracted the section 45(3) disregard. Secondly, the sale by PBL to MAR, which may or may not, here we assume did acquire 71A2 relief. Thirdly, the lease by MAR to PBL, which attracted 71A3 relief. And fourthly, the grant of the option to repurchase. And what my learned friend does is to drop out, when he's dealing with MAR, the transfer from MOD to PBL and say, well, that's nothing to do with MAR. But what one is asking is, in the context of a transfer or a transaction which involves one person, the MOD, disposing of a chargeable interest, another person, MAR, acquiring it. The only way one can reach whether or not MAR is P in relation to that particular transaction is to take all the steps along the line in order to arrive at MAR. Now, if one does that, and one therefore picks on the 2 or 3 elements which have led there to being no tax at all, which is the way my learned friends address this, they say the question is whether there was no tax payable as opposed to the tax payable on the notional land transaction. The reason there was no tax payable is first because the disregard under section 45(3) operated in relation to the passing of the property out of MOD to PBL, and secondly because section 71A operated twice in relation to the next, or possibly 3 times, in relation to the next 3 steps on its way through to MAR. all those are scheme transactions. All those transactions have their own tax consequences, and each of them has to be taken into account in deciding whether or not the conditions of Section 75A7 are satisfied. And if one takes my learned friend's view, which is that one looks how the amount was nil here, you can't disregard Section 45.3, or the disregard of Section 45.3. You've got to take it into account. And that's so whether you're looking at the transfer of the lease to PBL or the transfer of the freehold to MAR. In each occasion, you start from MOD and see how the passage of the property passed thereafter and what were the charges to tax. And when one does that, one has to say that either my learned friend's argument in relation to 75A7 is right as regards both MAR and PBL, because exactly the same scheme transactions operate in both cases, or it operates in neither. And we're perfectly content for it to operate in both. And if that's my learned friend's argument, I'm perfectly content to win my case on the basis that 75A7 doesn't apply to PBL for the reasons he's articulated in relation to MAR. But if it applies to both, if it applies to neither, then one goes back to the Court of Appeal's view, why look further than MAR in deciding who is P for the purpose of 75A?
The submission you're attacking is the one, is it, at the revenue skeleton 100?
Is it 113, something like
Well, just
yeah.
tell me which one I ought
I
to put a
apologise.
flag by.
I will try and locate it. One. I think it's a...
Is that the 100? It's a summary of it, but it's nice and short, and some of us
Oh, right.
prefer it short.
I apologise.
Can't be P because of 75A7.
And were MAR...
If MAR were P, then your shortfall provision, 75A1C, would be satisfied only by reason of 71A. But for 71A, MAR would be charged on the consideration of 1.25 billion. What you say is wrong with that, as I understand it, in summary, is that you only get to that result if you stop at the PBL to MAR transaction and don't treat all the transactions, including the subsequent ones, as a bundle.
And the previous one.
And the previous one.
Yeah, and the previous. The problem is really that what my learned friend is trying to do is start at PBL, but PBL cannot be V for these purposes because PBL doesn't have a chargeable interest.
I don't think anybody's saying that PBL is V.
So if one takes MOD as being V, then in those circumstances it has to be because the next step down the line is the transaction by which MOD transfers the property to PBL. And that gets a disregard under 45.3. And my learned friend's argument is if you find that there are two different reasons, one of which is not one of the ones which is mentioned in subsection 7, why there should be relief.
But if MAR is P for the purposes of section 75A, as you say, it must be P, must it, at the stage at which it acquires the freehold from PBL?
Yes.
Well, why don't you stop there then?
Because one has to determine what the scheme transactions are overall. And the scheme transactions, we say, involve one taking into account all the transactions which had been arranged, complying with the requirements of section 75A2D, which tells you that you've got to take subsequent...
I understand that.
Yeah. The argument doesn't require one to look... My argument doesn't require one for this particular purpose to look further than the acquisition of the freehold by MAR, because the revenue would already say, as far as PBL is concerned, that PBL is not entitled to the benefit of 75A7 relief, because from PBL's perspective, it says, it also gets the benefit of the disregard.
Well, it's not just section 71A, it's 71A plus 45.
Yes.
Yes, quite.
And that's equally true with the revenue, with MAR. Because the only way that MAR can get this property from MOD is via the steps which involve the disregarded transaction, MOD to PBL.
Yes, but you see, you're right when you say that 71A speaks of a bundle of transactions. It makes it clear right at the beginning that everything that it is contemplating has to happen under an arrangement between the financier and the customer. But it starts, that series of transactions within 71A starts with the purchase by the bank. Doesn't include, does it?
Yes, it does.
Whatever goes before that.
Well, it has to, in circumstances where if it didn't, one doesn't in fact satisfy the opening words of 75A1A.
Yes, I see. Because you've got V as the MOD.
Yeah.
Right. Got it.
Yeah. And I only refer to 113 because that's the detailed elaboration of the same argument. So my next step is simply identifying who is P again and looking at the way in which this exercise was undertaken by the lower tribunals and really addresses the manner in which the commissioners would like you to identify P in this court as well, because what my learned friend has said is that what the lower tribunal, what the first tier tribunal and what Judge Nolan did in the upper tribunal were effectively to adopt my learned friend's argument. And in the first tier tribunal at page 369, paragraph 162, one can see what the argument was. And it was the identification of P as the appellant, i.e. PBL, was obvious. The appellant was buying a property and financing it. It had remortgaged if it had remortgaged its acquisition in a conventional Western style financing, it would have paid SDLT and Section 75A would not have applied. And then similar arguments were advanced in the same way in subsequent tribunal. Now, the thrust of that is that there is something wrong with PBL having decided, or having had it decided for it, in all honesty, that the way in which this transaction should be undertaken should be Sharia compliant. There was no evidence whatsoever that this happened in that way in this case. And in fact, the evidence that existed was that there was a diktat that came down from on high from Qatari DR that MAR would be used as the bank. And the only financing that MAR undertakes is Sharia compliant financing, so it was inevitably going to be Sharia compliant finance. We also know that the legislature has devised two entirely separate strands of taxation of Sharia compliant finance and conventional Western finance. And in conventional Western finance, the tax charge falls on the mortgagor, the individual, and in Sharia compliant finance, the tax charge is going to fall pretty much, save in exceptional cases, on the bank. Because it's only in those exceptional cases referred to in 71A2 that the bank is alleviated from the charge. But whatever else happens, the individual never pays the tax because he's always protected by 71A3. But to say that the appellant was buying the property would have been right under Western finance. It wasn't quite right here, or it wasn't the end of the story for the reasons that I've given already. PBL didn't buy the property, MAR bought the property. What PBL acquired in the end was this long lease.
Plus the call options.
Plus the call option, and indeed...
Which were bound to be exercised.
Which eventually was
Because
exercised.
nobody was going to leave it as a long lease for 999 years.
But it hadn't acquired it at the time of the scheme transactions, and nobody suggests for one moment that the exercise of the final option somehow changed. At that stage, yes, of course, PBL acquired the freehold, but not at the time with which we are concerned. At the time with which we are concerned, the person who had acquired the freehold and was exploiting was the bank. And what the Finance Act 2003 says is, where a bank acquires a property in that sort of case, it pays SDLT on it. It cannot be right in my submission to say that the PBL can be the person who is liable for tax at P under Section 75A, because had it undertaken a different set of transactions, it would have acquired the relevant property interest and then have had a liability for SDLT. Now, at paragraph 240 of the First Tier Tribunal's decision, the reason, and this is at page 383, they say, agreeing with the Revenue's argument, construing 75A1A purposively, we consider P must be a person who has avoided SDLT that would otherwise have been payable. And in paragraph 242, having repeated their argument the appellant was buying the property and financing it, they say, in our view at 242, this approach was more consistent with the correct purposive interpretation of 75A. The appellant was acquiring the property with the benefit of finance from MAR, provided by MAR. By combining the release contained in section 45.3 and 71A, was no SDLT was paid by the appellant. It was not perhaps surprising that MAR paid no SDLT because its role in reality was that of a financier. Therefore, the real avoidance of tax was by the appellant as a result of the application of the tailpiece to section 45.3. Thus, identifying the appellant as P would be consistent with the purpose of the legislation. Well, that was the way in which the First Tier Tribunal decided that PBL rather than MAR was P. Because despite having decided that there was no tax avoidance element to Section 75A, they then identified as the person who was P the appellant because that was the person who had really avoided the tax. That rather Janus-faced approach to statutory construction was deprecated by Mr. Justice Morgan in the upper tribunal, where he also rejected the fundamental distinction between a funder and counterparty for Sharia finance. And his rejection is at paragraph 73 on page 312 of the bundle. One sees his summary of the analysis below, and he says, the First Tier Tribunal thought you should identify the party who was avoiding tax, also influenced by an approach distinguishing between the party acquiring the property and the funder of that property. HMRC said the choice of PBL was obvious, and in any case one should not select a party who had acquired a chargeable interest partway through the relevant scheme transactions, of which Mr. Justice Morgan said, I do not find any of those approaches to be appropriate. And then he goes on to discount quite rightly in my submission the possibility that having decided at an earlier stage that there is no tax avoidance element to Section 75A, one can build one back in when one identifies P. He says, what happens if there isn't anybody with a tax avoidance motive, having extended 75A to it? Or what happens if you have more than one person with a tax avoidance motive? Unfortunately, if one tries to find out why Mr. Justice Morgan decided that PBL should be P rather than MAR, one can only say that he rather ducked the issue and eventually decided that because Judge Nolan had considered that PBL alone was P, PBL should be accepted as being P because the commissioners have not sought to levy tax on MAR. And he says, and MAR is not a party to this appeal. And he says that at paragraphs 100 to 102 on page 320.
Sorry, 200 and...
320. 320.
Paras 100 and 102.
Paras 100 to 102.
Thank you.
And you see the summary at paragraph 102 when he reaches his decision, having adopted the decision. So Mr. Justice Morgan's approach came to this, that both PBL and MAR were capable of being P.
Yes.
But he was going to pluck the one who was in front of him and not consider why that should be. And essentially, in my submission, the decision of the learned judge comes to this. Since the commissioners had, in this particular case, decided to tax PBL, that was fine. If they decided to tax MAR instead, then that would have been fine as well, because it depended on whom the commissioners had assessed and who was in front of the court, whether or not it was right to say that they would pay. But if that is right, that gives the commissioners the discretion to tax or untax as they think fit. And would be wholly at odds with the fundamental constitutional principle that it is for Parliament and not the executive to decide where a tax liability should fall. And that, of course, is the decision of Lord Wilberforce in Vesti. And if I just give you the reference, it's at page 1717, 1717 to 1718 in the third authorities bundle, tab 56. And he said, well, that simply can't be so. And the result of Vesti was that the court decided it had to give a very narrow construction to the relevant provision, and narrower than the House of Lords had itself previously given, and was willing to overturn its previous decision because it led to that fundamentally unconstitutional position. One has, therefore, in my submission, to find some means of arriving at an identification of P, which gives one person...
So your MS number was?
Can I just check mine?
Not 1718.
That's Webb and Stanton.
Is it 17? Oh, it's 1171. I apologise. I think. No. It's 1713. What has happened is that my manuscript numbers are out by 4 in the later part of. Yeah,
that puts us back on course.
It's 1713 to 1714.
It's a very familiar statement.
It's from paragraph E on 1713 to paragraph F on 1714. Judge Nolan decided that PBL was P because the basic principle of SDLT was that duty should be imposed on the purchaser, not the financier, which Judge Nolan had said, Mr. Justice Morgan had said was wrong. And he also decided that the drafting error which led to there being no SDLT was the disregard under section 45.3, because he said the exemption under section 71A2 was entirely consistent with principle, and I would join issue with Judge Nolan over that in my submission, that if one looks at the operation of the disregard and the relieving provision here, the disregard makes eminently good sense because of that evanescent interest that PBL was acquiring, whereas the relief makes no sense at all because it was never intended and it was only ever have come in by a side wind. Given that this was not a case where the interest was genuinely acquired from somebody who was the counterparty who had previously paid tax on it, there was no purpose to the statute in giving relief in those circumstances. So if that is what the revenue's argument was, and the revenue said before you that in fact those arguments are the arguments which really adopted and applied its reasoning, then in my submission that those arguments are unsustainable, and the only approach that one can take, or the best approach at the very least that one can take in order to try and make sense and make Section 75 a provision which cannot be operated in practice, is to adopt the sort of approach which was adopted by the Court of Appeal of looking at the person who had acquired the chargeable interest, which had actually been disposed of by V and was going to be the subject matter of the notional loan transaction. And one can see that one could turn the issue a little bit and say, well, maybe even if Section 75A does not include a tax avoidance element, one could identify what the inappropriate tax advantage was and counteract that by treating as P the person who had enjoyed the inappropriate tax advantage. And if one goes down that line, then my argument again is that that was MAR and not PBL.
So you're saying that MAR got the inappropriate tax advantage?
If
that's the analysis.
If one starts from the position that it did get a tax advantage by enjoying a benefit of a relief under 71A2, which is the predicate,
Yes.
then in those circumstances that was not an appropriate relief to be given having regard to the overall legislative purpose and statutory purpose of Section 71A. It was not designed to capture that sort of case. And we say, of course, for the reasons we've already given, never did capture that case. And if the result of the introduction of Section 45(5)A was that briefly it did capture that sort of case, well, that would still make it an appropriate sidewind of something introduced for an entirely different reason. And in a sense, it's going to be a competition between different Ps, being the persons who acquire chargeable interest under scheme transactions, and it's a question of looking to see which of the persons who could be P in this counteracting the tax advantage world is most suitable to be treated as having been the person who acquired an appropriate tax advantage. My final point in this area is to explain to you the function of the derived from part of 75A1A, which is, or chargeable interest derived from the chargeable interest disposed of by V. If you could turn to page 1113. In the Authorities Bundle 1, find Schedule 7, the group relief provisions. And what the derived from chargeable interest provision was designed to capture were cases of a particular sort which would not otherwise have been caught or would have left one in a position where 75A could not actually capture the acquisition of the freehold if one assumes there's a freehold in the lease. So Schedule 7 provides group relief, and paragraph 1.1 provides group relief where there's a land transaction between a vendor and a purchaser who are members of the same group. And a group of companies is defined as a company and its 75% subsidiaries, and you can be a 75 subsidiary either directly or indirectly, as one can see from paragraph 1.4. So a very simple example is a group of companies consisting of A, which owns 100% of B, which owns 100% of C. And the legislative concern has always been, and this was both in stamp duty days and in SDLT times, was that SDLT could be avoided, and stamp duty could have been avoided by Company A, for example, giving a property that it wished to dispose of to Company B and then selling Company B, because you would then only pay stamp duty on the shares, and if the shares were, for example, located in overseas jurisdiction, you wouldn't even pay stamp duty on that. So that was known as the envelope trick, and steps were therefore taken, elaborate provisions built into Schedule 7, which are designed to remedy that and counteract that. And one can see in paragraph 3 that relief is withdrawn where, for example, in the case of a transaction that is exempt from charge by virtue of paragraph 1, the purchaser ceases to be a member of the same group as the vendor before the end of the period of 3 years, beginning with the effective date of the transaction. So as long as you didn't plan to dispose of the company within 3 years, you're going to be fine. And relief is then recaptured, clawed back, paragraph 3.1b. If at the time the purchaser, that's the company which has acquired the property from the other group member, ceases to be a member of the same group as the vendor, that's the relevant time, it or a relevant associated company holds a chargeable interest that was acquired by the purchaser in the relevant transaction, or that is derived from a chargeable interest so acquired. So there one has the same sort of language as one finds in 75A. One can ignore the rest. In those circumstances, group relief or an appropriate proportion of group relief is withdrawn and is chargeable in accordance with this paragraph. The problem arises from the definition of relevant associated company. But the simple case captures a case where Company A transfers a freehold to Company B in our structure, and Company B then grants a lease to Company C, and Company B then transfers the freehold, subject to the lease, back to Company A, and then either B and C leave the group together. In those circumstances, the freehold remains within the group, but B, the purchaser, and C, a relevant associated company, leave the group at the same time, clutching in their paws the chargeable interest derived from the freehold, being the lease which is now in Company C. So that works. It works, so you can't simply transfer a property in, grant an interest out of it, and then transfer the property back. Provided either the purchaser or a relevant associate of the purchaser retains the property at the relevant time, you are protected. The problem is, as I say, the definition of a relevant associated company, which is defined in subparagraph 4 in relation to the purchaser, as meaning a company that is a member of the same group as the purchaser immediately before the purchaser ceases to be a member of the group, same group as the vendor, and which ceases to be a member of the same group as the vendor in consequence of the purchaser so ceasing. So if one asks when a relevant associated company will cease to be a member of the same group as the purchaser ceasing to be a member of the group, it will only do so in consequence of the purchaser so ceasing if it is in fact a subsidiary of the purchaser. Because if it were the parent of the purchaser, that statutory description would not fit the transaction. Which meant that a structure known as the drop and bounce was introduced. And the drop and bounce was a case where Company A sold the freehold to Company C, which granted the lease to Company B and then transferred the freehold back to Company A. And if you then sold Company B together with Company C, C would have been the purchaser company, but B would not have been a relevant associate of the purchaser because it was not leaving the group in consequence of company C leaving the group. And this was the sort of case which was within the target area of the commissioners in 75A when they saw, well, if you are going to enter into transactions which could lead to that sort of consequence, we are going to make sure that if the real property interest which is being disposed of is the chargeable interest derived from the freehold, that will be captured by Section 75A, and it would be captured by 75A, even though it wouldn't be possible to go after or probably wouldn't be possible to go after the freehold itself, because that was back with Company A and doesn't leave the group. So complex structures which were being devised, which meant that one carved out interest and derived interest from properties which then were not themselves within Section 75A and couldn't be followed. In circumstances like that, the legislature was astute to make sure that even where the only thing which could be attacked was a derived interest, that derived interest would be brought within the charge to tax under 75A. It's a long stop sweeping up provision designed to capture extremely complicated cases, but not designed to capture cases, in my respectful submission, where there is a plain and obvious target, which is the interest which was disposed of by the vendor, by V. So the question is, which is the interest which is really being disposed of by V under the scheme transactions? Answer, if it's actually the lease because the freehold itself never really leaves V, then we go after the derived interest. If, on the other hand, V never gets the freehold back, or it is for some other reason outside the scope of the charge to tax, then we can go after the derived interest again. But if the interest disposed of by V is really there, then in those circumstances, P is the person who has acquired that particular chargeable interest, because it is plain that that should be the right answer. And it's worth observing that in this case, if one looks at what would have happened had there not been any reliefs from tax at all, the charge to tax that would have been on PBL would have been £18 million.
80.
1/8.
Oh, 18.
18. And that's because the way in which the leasehold interest would have been charged would have been at 1% of the aggregate of the rents, subject to a discount for being valued up front. You do a discounted cash flow or whatever to arrive at the right price. You look for the present value of the overall rentals under the lease for 999 years. So it would have been a substantial amount, but it would not have been in the same league as the amount that would have been payable by MAR, which would have been £50 million on the 1.25 billion that it paid, or was at that stage deemed to be paid. So that is why I say that one ought not to be over-concerned about the possibility of assessing somebody who has an interest derived from a charge of an interest. It's there for very special cases and not to be applied in the ordinary sort of case. My next submissions are whether or not I can make good the argument that Section 75A does indeed contain a tax avoidance element. As my learned friend says, I've been singularly unsuccessful in achieving this in courts below. And there are two elements to this. First is whether PBL avoided tax in this case, and the second is, well, does it matter? And although my learned friend continues to discount the relevance of tax avoidance in the tax avoidance section, there's a clear line in their printed case which was that either PBL was engaged in SDLT avoidance here, or as it failed to disprove that it was engaged in SDLT avoidance here. And our position is really simple, that there is no evidence that anybody was engaged in tax avoidance here at all. And it's certain that when one looks back over the facts as found by the first-tier tribunal, and the evidence that was unchallenged before the first-tier tribunal in the form of the two witness statements, which are contained in the appendix to the core bundle, that the real essence of this case was that, as I say, PBL was a creature of the Qatari Diyar. Qatari Diyar is the sovereign wealth fund of the state of Qatar. Qatar is an Islamic state, and the Qatari Diyar had shortly before these transactions been instrumental in the establishment of MAR, which was an Islamic bank which had an entirely Sharia-compliant product base. And not surprisingly, Qatari Diyar was very keen that PBL should make use of Sharia finance, especially in such a high-profile acquisition as the acquisition of Chelsea Barracks. All that was the real background to this case, and it's to be found, and I don't propose to take you to this in detail at the moment, I'll just give you the references. At paragraphs 9 to 19 of the witness statement of Mr. Sherwood King, which is pages, and I'm just going to check this, 969 to 973 of the manuscript. Paragraphs 11 to 17 of the witness statement of Mr. Latif, which are to be found at pages 1000 to 1002. And then it was also the subject of certain findings by the first-tier tribunal, which are to be found, the relevant findings to be found at paragraphs 8a, 32, 34, 47 to 52, and 63 to 65.
That's the first tier.
That's the first-tier tribunal. Those were its findings.
Yeah. Do you have a... Oh, well, I can find those.
The page number is 345 for paragraph 8 and 349 to 354 for the list.
Thank you.
So, as we say, what Mr. Sherwood King was saying was it was perfectly clear that the sequence of events in this particular case was that Qatari Diyar said this form of finance is going to be used and the bank is going to be MAR, and the orders having come down from Qatar, they were implemented in the only possible way in London, and that's paragraph 15 of his witness statement. So that's the basis on which the transactions happened in this particular way. It wasn't anything to do with ducking the use of ordinary mortgage finance, because there happened to be a more effective way of doing the transaction from an SDLT perspective. It's also been suggested at various times that another unusual aspect of these transactions is that before the Islamic finance had been arranged, that PBL had contracted to buy the property from the MOD. And the reason for this is explained by the witnesses as well. And it runs as follows, that in order to ensure that it received the best price for the property, the Ministry of Defence instituted a sealed bid process. That's paragraph 10 of Sherwood King at page 969.
Sorry, page?
Page 969.
Thank you.
And that was a process which a small and recently formed financial institution such as MAR would not have been well adapted to use, and that's paragraph 9 of his witness statement. And in addition, the ministry was unable to give vacant possession for nearly 9 months. Apparently it had yet to arrange the relocation of the troops which were stationed there at the time. And that's paragraph 14 of Mr. Sherwood King's witness statement. And payment was to be staged over 4 years, and that's paragraph 11. And so it was unnecessary for the funding for the purchase to be set in stone before the contract was made. And there were various logistical reasons why it wouldn't have been easy to get the Ministry of Defence to have accepted MAR as a bidder in any event. That's Sherwood King again. And before the first-tier tribunal, the line of argument which was advanced by the commissioners was that, well, the transactions could still have been undertaken in a Sharia-compliant way, but in a different Sharia-compliant way. And it could, for example, perhaps have novated the contract and gone down that route, substituting MAR for PBL as the contracting party under the MOD contract. And that was rejected by the first-tier tribunal at paragraph 389 to 300, paragraphs 278 to 280 at page 390 of the first-tier tribunal. And they described that as misconceived. And the commissioners also attempted before the upper tribunal to argue it would have been open to PBL to acquire the property first and then later to have sold it on to MAR, in which case the SDLT consequences wouldn't have followed. My submission was, it doesn't actually appear in the decision, was equally far-fetched because it's hardly likely that MAR would have allowed PBL to have laid its hands on the money to acquire the property without acquiring the property interest itself. And it couldn't have lent the money on some other terms because that would have been completely non-Sharia compliant. So the idea of breaking the transaction into bits and being able to avoid the automatic operation of Section 45.3 was simply not on. There had to be a structure which would both satisfy the bank's requirement that it obtained the property it was paying for and that it would not be lending money to PBL, and that required simultaneous completion of the kind which happened here. And the relevance of that is that Section 45.3, of course, is not a relieving provision. It's a disregarding provision. And because it's not a relieving provision, it doesn't have to be claimed. In fact, you can't disclaim it. It happens automatically. Once there was a pair of simultaneous transactions, the section was engaged. And in fact, when we get to a later part of my case, the commissioners themselves rely on the fact that this was so when they were discussing whether or not the commissioners amended the right return, because they say you didn't need to make this return because you don't need to make a return because Section 45.3 operates automatically. Lastly, the commissioners themselves tried to advance a number of evidential aspects which they said pointed towards there being evidence of tax avoidance. Most of those were rejected. They tried to argue, as I say, that it could have been structured in a different way which would not have attracted a complete absence of charge. Those are all discussed in paragraphs 278 to 280 of the tribunal's decision that I've already drawn to your attention, all of which were decided and considered to be misconceived. And then they said, well, we also draw your attention to the fact that Mr. Justice Morgan was expressed regret that there wasn't more evidence on the precise requirements of Sharia law. And he says that on page 291 of the bundle. It's at paragraph 24 of his judgment. But when you look at what he says, what he is actually saying is, the evidence isn't as detailed I would have liked in particular to enable me to consider the human rights arguments, which emerged at a late stage before the first-tier tribunal. And the reason why there wasn't anything more than simply the written witness statement of the evidence of Mr. Latif was that Mr. Latif's evidence was submitted in accordance with the tribunal direction 6 months before the first-tier tribunal hearing. And before the tribunal hearing, oral proceedings came on, the commissioners indicated that they weren't going to challenge the evidence, and therefore the witnesses weren't called to give evidence which could have been more carefully cross-examined on. And if the matters go to the human rights issue, then your ladyship may remember that the basis on which the commissioners were granted permission to argue that the correct amount of tax was 50 million rather than 38.36, which is the area and the only area in which the human rights issue raises its head in this case, was because they argued that they should be granted permission to advance that submission at a very late stage on the basis that it was a pure point of law, not requiring factual evidence nor witness evidence. But it can hardly be right if to turn around at this stage and say, well, it's therefore something which this court ought to take into account, that there wasn't adequate Sharia law evidence. Now, clearly, Mr. Justice Morgan himself would have disagreed with this analysis and would have preferred to have further evidence, but it was too late by that time. As it happened, he never had to decide the issue because he came to the conclusion that the right amount of tax was 38.36 without recourse to a human rights argument. And from all that, I say three things. First of all, that the Commission has failed to identify any way in which these transactions could have been undertaken other than the transactions which were undertaken. Secondly, if Sharia finance were to be used, there would inevitably have been a subsale to PBL, followed by an immediate acquisition to the bank, having regard to the factual structure that existed here, the bid process and so on. And thirdly, any arguments that the commissioners may have advanced that these transactions came about as a result of careful planning by PBL or MAR or somebody else designed to mitigate SDLT are misconceived because there was nothing in the point at all. So we say that there is an absence of evidence of tax avoidance, and which takes me to the legal question, which is, does Section 75A require proof of tax avoidance before it's engaged? And of course, my starting point is that's what the heading says. It's not perhaps, of course, what one might consider a killer blow, but it is headed Section 75A anti-avoidance. And
Well, I suppose you can avoid things without meaning to.
It might be said that in order to avoid something, one has got to appreciate that there is something to be avoided and then take steps to do so. That one steps round something which one might otherwise have run into, and to say that you avoided a problem there by happenstance is perhaps not.
Well, how do you define avoidance in this context? It's something that's been puzzling me.
Well, yes.
I mean, I might narrowly avoid being hit on the head by something falling from a great height, but that's not because I knew it was going to fall from a great height, it's just because I walked through a second before it fell. And you would talk about my having narrowly avoided being hit on the head.
Yes.
One might, but in the context of a tax avoidance section, I'm not entirely...
Oh yes, tax avoidance may be something different.
Yes.
A special meaning, yes.
Yes.
Well, tax evasion is clearly something different.
Oh, yes.
What about
Yes, oh, absolutely. And the only thing I brought to your attention here is Willoughby, where it's at tab 44, pages 1079b onwards.
107.
That seemed to be the numbers I've just...
179.
doesn't seem to
1079
be-
is just...
It's,
oh,
it's,
this
it's
is
tab
added.
44 in volume 3. If I go there and then find...
About
reference,
1642 or thereabouts.
I'm much obliged.
Volume 3.
Volume 3, tab 44, page 1642 to 43.
Oh, yes.
And this, of course, only was in the context of a particular taxing section, which itself required tax avoidance. And at the first break, one sees, in order to understand the line thus drawn, submitted Mr. Henderson, it was essential to understand what was meant by tax avoidance for purposes 741, to be distinguished from tax mitigation. Hallmark of tax avoidance, taxpayer reduces the liability of tax without incurring the economic consequences that Parliament intended to be suffered by any taxpayer qualifying such reduction in his tax liability. Mr. Henderson, as he then was acting for the revenue in this case. The hallmark of tax mitigation, on the other hand, is taxpayer takes advantage of a fiscally attractive option afforded to him by the tax legislation and genuinely suffers the economic consequences Parliament intended to be suffered by those taking advantage of the option. Where the taxpayer's chosen course is seen on examination to involve tax avoidance as opposed to tax mitigation, it follows that tax avoidance must be at least one of the taxpayer's purposes in adopting that course, whether or not the taxpayer has formed the subjective motive of avoiding the tax. So one can objectively identify tax avoidance. My lords, I am content for my part to adopt these propositions, generally helpful approach to the elusive concept of tax avoidance, and all the more so since they owe much to the speeches of Lord Temple and Lord Gough in Ensign Tankers. And then he decides on the facts of that case that there isn't, in fact, any tax avoidance. All that was happening was that the parties in question were pursuing socially acceptable objectives. So if one asks that in the context of 75A, and presumably one has to ask that in the context of the person who is P for 75A purposes, one asks whether or not PBL obtained a tax advantage without suffering the economic consequences that would have been expected by Parliament for that person to have suffered in order to obtain the relevant relief.
But that's got no subjective element in it at all. I mean, the definition here.
Well, one then goes back to...
It's just doing something which has the consequence of not paying tax without suffering the economic consequences which Parliament intended.
Indeed, but the question is whether or not, if one looks at the transactions which were undertaken here, and the reliefs, I suppose, whether one can avoid a disregard is a different question. But leaving aside the disregard and focusing on the reliefs, the question what comes back to is pretty much central to questions I've been articulating already in relation to how one identifies who it is who ought to be, which is when you look at MAR and PBL in the context of 71A, were these two parties persons who individually have obtained the relief without suffering the economic consequences which ought to have followed? And in my submission, whatever you may say about MAR, and MAR isn't in front of us, as far as PPL is concerned, it isn't such a person.
Just sticking with Willoughby for a moment, Mr. Thomas, the section in question was section 741.
It was.
Of the, what is it, ICTA, is it? Yes.
It was.
Okay, now what did it say? Did that talk about reasons other than tax avoidance?
739 was a transfer of assets abroad provision whereby you parked your assets outside the jurisdiction of the United Kingdom and then made sure that you didn't pay tax on them. And what 739 was to bring those back into charge if you had power to enjoy the benefit of the use of those provisions. 741 was a provision which enabled a taxpayer to fall outside the scope of the section.
Quite. If
he was able to show that he did not have the object of avoiding tax.
So
So there was a positive,
So those sections,
Yes.
or at least section 41, was cast in terms of the subjective intention of the taxpayer.
it was.
And this one isn't, is it?
No. No, indeed not. But what I derived from that is whether you're looking at a subjective or an objective position, the question is whether or not it could rightly be said in relation to PBL in this particular case that this is a person who has obtained a relief under the Act here in circumstances where Parliament where it hasn't suffered the economic consequences that Parliament would have expected it to have done. And I say there's no evidence that that was the case at all.
The hypothesis for all this requires one to assume, doesn't it, that PBL gets the benefit of 71A2.
Yes. No, 71A3.
Oh, yes, it's 3. It's MAR. Well, yes, it's
Yes.
MAR.
MER
the benefit
gets
of
subsection
2.
2.
Yeah.
Yes. But that PBL gets the benefit of the disregard not being disapplied.
Yes, yes. And then you ask whether or not the circumstance... I'm taking the disregard as an easy case. If one actually found that the way in which the transaction was handled was such that, far from not enjoying the benefit of the pass-through of the chargeable interest, by some devious means the intermediary had retained for itself most of the benefits of the freehold but passed a shell on to the transferee. In those circumstances, one might say, well, that would have been a case where the economic the economic burdens had not been imposed on the intermediary in the way that Parliament would have expected, because Parliament expected this property to pass through without there being any long-term interest in the property retained by the transferor. But that isn't this case. As far as the relief is concerned on 71A3, PBL entered into a series of transactions, all of which operated, as far as PBL was concerned, in the way that the legislation was designed to do. And in those circumstances, in my submission, there isn't, as a matter of fact, any tax avoidance. And what is more, when one looks at the narrative of facts which I presented to you earlier, I would also submit that there's no evidence of tax avoidance of a kind which would then engage the operation of Section 75A. What I have more difficulty with, and I thoroughly admit this, is finding in Section 75A a large number of pointers to the requirement itself. I can rely on, obviously, the side note. Montier allows me to rely on the side notes. They are clearly part of the contextual setting. If one is looking for other things, they are few and far between. But one could, I suppose, look at the way in which the language addresses it. For example, the use of the phrase scheme transactions to describe the overall process by which a charge arises does indicate that the Parliament had in mind that there was going to be a scheme, the consequence of which was going to be that tax would be avoided in the way described in 75A1C. But I can't make my case better than that. That's all I can do, and that's as far as I take it.
And trouble is, the scheme is a sort of definitional construct applied to any situation where 75A1B is satisfied.
But one can imagine all sorts of cases where 75A would otherwise be satisfied, which simply would not be a scheme transaction. The example I gave below was a sub-sale on a falling market. Say A sells to B, contracts like the Ministry of Defence does for a long completion date, sells a property for £2 million, and B is, by the time completion comes around, very short of cash, and is able to sell it on for £1.5 million to C. And in those circumstances, A gets, say, the £500,000 by way of the deposit, gets the rest of it from C. In those transactions, you obtain subsale relief. Should C pay SDLT on £1.5 million, or should C pay SDLT on £2 million? The revenue's view originally was, well, actually, we think C should pay tax on £2 million by reference to Section 75A, even though C may not even be aware of the price that be paid A for the property. Because if one applied Section 75A1 in those circumstances and go through the paragraphs, they do apply to the transaction question. They can catch entirely unexpected circumstances which could be alleviated if one were to build into the transaction a condition of its that you require tax avoidance. And if you go to page 1309 in the bundle, it's tab 18 of the bundle. I'm not sure I'm getting the right number.
18.
Yes, it's MS 1309.
It's a revenue explanation of Section 75.
It is indeed, and
Online guidance.
It's the guidance, and all it says is overall approach. 75A is an anti-avoidance provision. HMRC therefore take the view it applies only where there is avoidance of tax. On that basis, HMRC will not seek to apply 75A where it considers where it considers transactions have been taxed appropriately. Well, it's a fairly self-serving comment, and it doesn't take one very far. But one can see that was the line that was being taken by HMRC at an earlier stage. So maybe it's not an entirely hopeless argument. Which takes me on to the wrong return point, which is a very technical submission and breaks down into a number of different points, but it's really important because if it is correct, it's a complete answer to the revenues assessment in this case.
What did you call the point?
It's called the wrong return point.
Oh, the wrong return point. Thank
Yeah.
you.
They've all got catchy titles.
I forgot that one. Yeah.
And it's comprised of a number of different elements. The first is whether or not there was actually any obligation on PBL to submit a land transaction return in relation to a Section 75A land transaction in any event at the time that these transactions took effect. That particular point arises from the way in which the obligation to file land transaction returns existed in Sections 76 and 77 at the relevant time. What happened was that they were amended some 6 weeks later after these transactions were took into effect. And one can see the various iterations at Core Bundle 1, page 251. And if one looks at Section 77, one sees that it went through a number of different amended versions. And it's only when one gets to the one on the 12th of March 2008 which one finally finds buried at the bottom, paragraph 1D, that one of the notifiable land transactions is a notional land transaction under section 75A. Before that time, the section specified what land transactions were notifiable, including the grant of the lease and so on, and also including, as early as section, as the 18th of March 2004, in subsection 5, a land transaction that a person is treated as enter into by virtue of subsection 3 of section 44A. This is a deemed notional land transaction. So the point is simply this: where the legislature intended that a notional land transaction should be the subject of a return, it made provision for it. It did so in relation to section 44A on the 18th of March 2004. But it didn't get around to doing so in relation to a 75A notional land transaction until the 12th of March 2008. And we say, therefore, that there was no obligation on the 31st of January 2008 to file a land transaction return in relation to a notional land transaction. Now, that point was decided against me below, and the way in which the courts below got round this was to say, well, you don't really need a specific reference to a notional land transaction, because if the relevant land transaction, such as the transfer of freehold, is already captured by the principal section or the other provisions of the section, then that's sufficient and it captures a notional land transaction as well. It's a matter of statutory construction, but I rely on it as being an indicator that there wasn't, in fact, an obligation to file a land transaction return at the relevant time. And one can, in my submission, understand why it might have been thought originally that it wasn't appropriate to file a land transaction return in section 75A. Partly because there was this view expressed by the revenue that they were the ones who chose as and when section 75A should apply, and they were the ones who should choose the person on whom section 75A should fall. And if that was so, it was going to be pretty difficult for a taxpayer to know whether or not he was going to be the person who would be P, having regard to the difficulties of the section. And certainly Mr. Justice Morgan was concerned about the difficulties of the operation of the section in arriving at a conclusion that, notwithstanding that, there was actually a statutory obligation right from the start to file a land transaction return. So the first point is, was there in fact any obligation on PBL to file a land transaction return at the relevant time? If it wasn't, then it could hardly be faulted for having not done so. And it hardly lies in the mouth of the revenue to pick on some other land transaction return that it did file and pretend that it was actually a 75A return. Because what they did here was, in fact, to select the land transaction return that was used by PBL to file the disregarded transaction under section 45.3 and return that. Now, I'll come back to that point in a minute, but we then go to section 76, which is the section which casts on a taxpayer an obligation to file a return. That's at page 1167. 1167. In the case of every notifiable transaction, the purchaser must deliver a land transaction return to the Inland Revenue before the end of the period of 30 days after the effective date of the transaction. So that's your time for delivery, your return. And then at page 1178, one finds Schedule 10, paragraph 1, which defines a land transaction return and says a land transaction return must be in the prescribed form, contain the prescribed information, where prescribed under paragraph 2 means prescribed by regulations made by the Inland Revenue. And there are such regulations. They are the SDLT Administration Regulations of 2003, which are at page 1319.
One 1319.
1319.
Thank you.
Where one finds paragraph 9 on the form and content of land transaction returns. And that provides that a land transaction return must be on the form prescribed by Part 1 of Schedule 2, or in a form that has been approved by the board. Well, as far as Section 75A returns are concerned, the board had, in my submission, approved a method which is to be found in a technical news bulletin number 6, which they published at the very end of December 2007, the beginning of early January 2008, which is at page 1304. And about a third of the way down, one sees 75A notional land transactions. Some have asked how notional land transactions affected by the anti-avoidance legislation introduced by FA 2007 should be notified to the Commissioners. The Commissioners wish to avoid any confusion that could arise if practitioners try to file an electronic return or a paper version in respect to Section 75A returns, in addition to a return for the real transaction. Practitioners therefore advise they should notify details of the notional transaction separately and by letter to Birmingham Stamp Office. So the way in which the Commissioners were inviting people to file returns was by letter to the Birmingham Stamp Office. You don't file an SDLT1, which was the form that you would ordinarily use, because everybody would get confused.
Surely not.
Sorry, what was the page reference to that?
1304.
Thank you.
So what actually happened here, as I said, is that Commissioners, when they got to inquire into the returns, inquired into all the returns and focused on the return that EBL filed in relation to the Section 45(3) transaction or non-transaction. And it's right to say that was made in relation to a transfer of the freehold which was disregarded. But the reason why it was filed was that by filing it, the taxpayer was supplied with a document by the Commissioners, which could then be provided to the Land Registry in order to secure the registration of the ultimate purchaser without undue delay. And this was explained to Mr. Buttery, who was the investigating inquiring officer, by a letter from Clifford Chance dated the 16th of January 2009, which is at page 1006.
Sorry, page 2?
1006.
1006.
It's 16th of January 2009.
Yep.
And if you go through to 1011, there's an appendix where the transactions are described to Mr. Buttery. And at 2.2, it explains about the reason for filing that return. One was filed in order to obtain a revenue certificate for production at the Land Registry in accordance with guidance that HMRC had previously provided to the property PSL group as follows. The SDLT legislation permits subsale relief on a double conveyance. The Land Registry rules are not in practice may not in practice permit it, we've given advice that in an ABC, where both B and C are conveyed, B may submit an SDLT1 and claim relief code other, that's code 28, goes in box 9 for section 45.3, B will then get a certificate. So the reason they did it was because they'd been advised by the revenue that that's what you do.
You didn't presumably write a letter to the Birmingham Stamp Office?
No.
No.
And I'll come back to not writing letters to Birmingham Stamp Office. And if one goes to page 771, one can see the return.
Sorry, page?
771. It's in core bundle 2. And if one goes down it, one can see various codes are used throughout, but the type of property is O3, which I seem to remember is freehold. The date of contract, box 6, is the 5th of April 2007, so one immediately sees this as a reference back to the Ministry of Defence contract. The effective date of the transaction is 31st of January 2008. And then if one goes over leaf about the tax calculation, are you claiming relief? Put X in one box. Yes. If yes, please show the reason. And the reason code is 28, which you'll remember is the reason code that the revenue had given should be used in relation to a section 45.3 transaction. So this is quite clearly, on its face, as explained to Mr. Buttery before he ever issued the closure notice, a land transaction return which was given in order to generate the receipt which could then enable land registration to take effect. Then at page 848 we get to the closure notice, which didn't come out till the 13th of July 2011. And it's one of the facets of this case that the revenue dragged their feet quite dramatically over the way in which the inquiry proceeding in a somewhat dilatory way.
So could you give me the reference? I'm so sorry.
848.
Thank you.
And at the very top, you get the date, 13th of July, and then you get a reference, 307, and so on, which is a reference to the relevant land transaction return. And it says, information about our check into your SDLT return, paragraph 23 of Schedule 10, that's the relevant closure notice rule. I've now completed my check of your SDLT return in respect to the transaction dated 31st of January 2008. This letter is a closure notice issued under paragraph 23. I'm sending a copy. My conclusion. I have amended your stamp duty land tax return to reflect my conclusion. Do not look for a conclusion. You will not find one. That is it. It previously showed you were due to pay £0. It now shows you're due to pay 38.36
Well, it tells you what the conclusion is. It just doesn't tell you how he's got to it.
It does. Yes, his conclusion is that you've got to pay tax and you've got to pay tax of 38.36, but it doesn't say why. And then it goes on to calculate the interest. Then it tells you to pay the money. Yep. And then overleaf, just note that if you disagree with the decision, you can appeal. You can also write to the commissioners telling us why you think our decision is wrong. We will contact you to try and settle the matter. If we can't agree, we will write and tell you why. We will then offer to have it reviewed by somebody who's not previously been involved, and then we'll tell you about your right to go. So the whole swathe of processes which are supposed to happen afterwards, which will take time. But PBL cut the Gordian knot, and what it did was to send a letter of appeal in on the 8th of August 2011, which is at page 853.
Eighth of August 11.
The 8th of August 2011.
Yep, thank you.
So well within time.
Yep.
It was pretty prompt about getting a notice of appeal out, or letter of appeal. So pursuant to paragraph 36, we hereby appeal, and then they set out the grounds of appeal. And it was trying to cover the thing in a comprehensive way. The first ground of appeal is that the original contract with the Ministry of Defence, under which PBL acquired the relevant property, became the subject of a transfer of rights within the meaning of Section 45, with the consequence that the completion of the original contract at the same time as, and in connection with completion of the secondary contract, fell to be disregarded. And the completion of the transfer of rights and subsequent lease of the relevant property of the appellant fell within the terms of 71A and were accordingly exempt from charge pursuant to 71A 2 and 3. But you can see that the starting point is that the first transfer was a transfer of rights within the meaning of 45, with the consequences as described. And then it goes on. So what it's saying is those were the reliefs. This is the transaction. This was a Section 45.3 land transaction return, and it was a correct Section 45.3 claim, or has to be treated as a claim for relief because that's the box that you use. And then it says there was accordingly no land transaction in relation to which the appellant was chargeable to STLT. That's ground one. Then ground two is, to the extent that the conclusion the closure notice relates not to an actual transaction, but to a notional transaction, it doesn't apply, first of all, because that's an anti-avoidance provision. Secondly, it doesn't, upon a proper interpretation, permit the imposition of tax upon a person, such as the appellant who is not engaged in a tax avoidance scheme. Secondly, even if 75A were in principle applicable here, PBL is not P. And finally, 75A7 operates. So it was about as comprehensive as one could have imagined.
Well, yes, and also, never mind that the closure notice didn't give much in the way of reasons. The reasons were obviously under discussion.
They were, and absolutely, there had been correspondence between the parties under which these things had been discussed. Yeah. But the reasons which were being given were twofold reasons, and the reasons which go to the actual land transaction is this is an actual land transaction return in relation to a Section 45.3 disregard. And that was, you only then go on in the alternative, if what you're trying to do is this instead. But both arguments are in play, but the argument that's being put forward is this is a land transaction return, which is correct. There was no point in PBL referring to ground one in the context of an amendment of a land transaction return, unless that return was intended and designed to reflect the transactions to which it was describing. And this one reflected and described the Section 45.3 transaction.
Or non-transaction.
Or non-transaction. But nevertheless, it was something which was necessary because of the way in which one had to get a certificate of the revenue in order to generate a registration at the land registry.
So it's from ground one, is it, that we get the assertion which was being made at that stage, and as I understand it, right up until sometime after the first-tier tribunal, that the vendor in the 71A transactions was PBL?
Well, it's
has to be, otherwise it doesn't get it into 71A too.
Right.
Well, PBL is not concerned about 71A2.
It says it is.
It's describing the entirety of the transactions that took place, but it's not concerned with 71A2 itself because...
Well, it has an economic concern because it's probably given an undertaking to pay MAR anything it has to pay by way of tax.
But this is a closure notice amending a return by PBL. It's not a closure notice amending a return by MAR.
No.
So it can't possibly be concerned at this stage with what's happening about 71A2.
Well, it probably is very concerned, but you say not for this purpose.
Yeah.
Well, it's 71A2 and 71A3 are both referred to. So the lease to PBL is referred to. I mean, what it's quite clear is it's making a claim that there is nil tax due on any part in respect to the transaction.
Yes, and it's also making a claim that each and every one of the land transaction returns which were filed were correct.
Yes.
Yeah. And it follows from that.
The only way that 71A2 can apply is if PBL is the vendor. Because you're talking about PBL's liabilities, you've just said. Not interested in MARs.
Yeah, but Even if Section 71A2 did not apply, it would not be the position of the revenue to impose tax on PBL because 71A2 did not apply.
Right.
It can't possibly impose tax on another taxpayer.
No, I understand that.
The PBL may not have a direct interest in
Yeah.
71A2, but as Lord Briggs said, in their contract with MAR, they probably did.
Yeah.
Oh, yeah.
I mean, it's common ground, isn't it, that there was a stamp duty indemnity from PBL?
Yeah, absolutely. No. My only point here is that what we are concerned with is the land transaction return, which is the land transaction return I've taken you to already. And the argument that's being made in relation to that land transaction return is it's right. And it's right because it claimed Box 9, Code 28 relief in accordance with the directive.
Saying there wasn't a land transaction.
So it was still a land transaction return
Yes,
even though it wasn't a land transaction.
It was a land transaction return saying that the underlying transaction was not a land transaction.
Yes. But it's still a return made in relation to a particular point.
Although it's not saying in its case about the notional transaction, i.e. ground 2, that in any event you can't amend the return because you'd be amending the wrong return.
No, it doesn't specifically say that, but in my respectful submission, it was always implicit in the fact that it was saying what the return was, that it wasn't a 75A return. And my argument is that if one goes back to the way in which the legislation works, one makes a land transaction return under Section 76, 77 and Schedule 10, Paragraph 1, in relation to each land transaction. Each land transaction has its own return. You don't have a single return which covers a number of different transactions, which is why in this particular case, there being 5 different events, I think, which involved the parties here, there were 5 different land transaction returns which were filed in relation to the options, in relation to the lease, in relation to the disregarded transfer of the freehold from MOD, and one by MAR in relation to the transfer from PBL to MAR. You file a land transaction return in relation to a specific land transaction and nothing else. And therefore,
or a specific non-land transaction.
Therefore, when one, yes, and a non-land transaction in this particular case. Therefore, when one comes to look at the inquiry provisions, which are page 1180A,
This is it.
this is paragraphs 12 and 13 of Schedule 10. Now, I'm not quite sure how they're built into your
They came separately.
They're not. They must be separate.
They arrived by email yesterday, I think, possibly the day before, and with a letter saying that there were 2 documents, and I think there was probably only one. But anyway, if you've got the hard copies, which we have,
right. If you've got the hard copies,
have we?
Yes.
Which paragraphs do you want?
We're looking at paragraph 12 to begin with. One sees
Yes,
that
but we've got them electronically as well.
We have, have we?
Yes, we have.
We only have one of them electronic.
the Inland Revenue may inquire into a land transaction return if they give notice of their intention to do so to the purchaser before the end of the inquiry period. So they're inquiring into a land transaction return. That's the starting point.
12 we've got, certainly.
Yeah. Then 13, the scope of the inquiry. An inquiry extends to anything contained in the return or required to be contained in the return that relates to the question of whether tax is chargeable in respect to the transaction or the amount of tax so chargeable. Now, that has to be, in my submission, an inquiry into the transaction of whatever description it may be, which is contained in the return. It's not a broad and roving inquiry into any other land transactions that you may have undertaken.
And so it doesn't include a notional Section 75A transaction, you say?
Unless you've made a return of that notional Section 75A land transaction by letter to Birmingham.
By your letter to Birmingham?
Yes.
Yes.
So what this wasn't What the revenue could only do, the only thing the revenue could do in relation to this particular return was to inquire whether or not it was correct by reference to the disregarded land transaction. And in doing so, they would have had to inquire for their own purposes whether or not the use of reason 28 was correct. Or whether, in fact, this was an actual land transaction return which was not entitled to the benefit of the reason code because PBL had not satisfied the conditions of section 45.3 tailpiece in undertaking the transaction.
Is there anything relevant in 13.2?
No, that goes on if
that's the purchaser's amendment, is it not the revenues amendment?
Yes, that's right. If you later return an amendment, then you extend time and so on. Yeah. But in my submission, the powers of the revenue to inquire into this particular land transaction return were constrained by their powers as conferred on them by paragraphs 12 and 13. And they didn't include a power to treat this as a transaction other than the transaction it actually was.
So what are they supposed to do?
Well, they had a number of different choices. If as the revenue say that you were obliged to file a return and you didn't,
then you'll call for one, do you?
Then what you can do is you can issue a notice of determination under paragraph 25.
Right.
Which is at page 1182. And one sees if in the case of a chargeable transaction, no land transaction return is delivered by the filing date, the Inland Revenue may make a determination to the best of their information and belief of the amount of tax chargeable in respect to the transaction. So that's one step that they can take. That's
yes.
Yeah. And then paragraph 28, which is at 1182.
That's got to be a chargeable transaction. Is I suppose the notional transaction under 75A is it?
It inevitably will be,
Yes.
because otherwise you don't get a tax charge. So if you have an obligation to file your return, you don't file a return, the revenue can send you a notice of determination. And the effect of a notice of determination is it's treated as if you had actually filed a land transaction return yourself in that amount.
Yeah.
And you pay the tax. But what you can do is then amend or file a land transaction return which replaces it, and then you argue over the replacement land transaction return. The alternative thing they could have done was under paragraph 28, which is to raise an assessment on the basis that they had discovered, as regards a chargeable transaction, that there had been a loss of tax. So there was a choice open.
And is there a 6-year time limit for that as well?
Well, at the time, actually, this time, although these are slightly, by the time it came around, I think we were down to 4 years rather than 6 years, but that was. By the time of the closure notice, I think the period had dropped to 4 years from 6 years.
Which paragraph was that you mentioned?
The 6-year period.
Yeah.
No, the assessment.
The assessment.
The assessment is paragraph 28.
28, so I think.
Yeah. The time limits for assessments are in paragraph 31.
I don't think we have 28.
No, nor 30.
It's on 1182A.
Yes.
That's the one that didn't get round.
Yeah.
May not have got through.
I don't know whether revenue's got additional copies that can be made.
We have got a hard copy. Got a hard copy. No.
But there's a choice of methods which would be open to the revenue. So it's not as if it's disastrous. It's just a question of making sure they apply the remedies that are available to them.
Do the right thing.
And what we say is that in those circumstances, what you have to do is to look at the return that was made, and you have to decide what that return was intended to do. And in my submission, having regard to the information that was available to the revenue at the relevant time, they would have been perfectly knowledgeable that this was, because they'd been told that by the letter of the 16th of January. They'd been told why it had been filed in that form by the letter of 16th of January. And in fact, they would also have known that you don't file a 75A return on an SDLT1 because they themselves, 3 weeks before the transactions took effect, had issued that Tech News 6 notice saying, write to Birmingham. So if one is applying the usual sort of construction of document approach of what is this document and can it be considered to be a section 45(3) return, or can it properly be considered to be a section 75A return, the answer is it's obviously the one, plainly, just as obviously not the other. What actually happens is in the upper tribunal, Mr. Justice Morgan somewhat reluctantly comes to the conclusion that there was an obligation to file a Section 75A return. He then goes on to say, how does one interpret the relevant return? He does this at page 327.
Paragraph?
The reasoning is at paragraphs 117 onwards, I think.
Thank you very much.
Paragraph?
117 onwards.
Oh, well, that's 325.
Yeah, which is a little earlier.
You've got your page number probably in the back.
How to interpret the return?
That's where it starts. And at paragraph 121, he says, despite the review of the statutory provision, he concludes the notional land transaction was notifiable under 76 and 77. But he remains concerned that because it's a difficult section to interpret, it may be difficult for people to file a return under 75A. So he then asks the question in 123 whether the return delivered in relation to the section 45(3) point should be considered to be a return of the actual transfer or a return of the notional land transaction. And he says if the return related to the actual transfer, it was an unnecessary return. Further, if the statutory return related to the actual transfer, the result was that PBL failed to perform its statutory duty to deliver a return in relation to the notional land transaction. Well, maybe it did, but that's beside the point. With some hesitation, I consider the return in question can be considered to be a necessary return rather than an unnecessary return, which performed PBL's obligations under Section 76 to deliver a return. On this basis, it was a return in relation to a notional land transaction in accordance with 75A. And with the greatest respect to the judge, in my submission, that was an impossible construction to place on this particular document, having regard to the background consisting of, first of all, the letter or the guidance which had been given by the commissioners to the PSL group as to why you should fill a form in this way, and the actual letter or Tech News which the Revenue had published in January saying that you don't file a 75A return by means of an SDLT1. So for those reasons, we say that the proper construction of this was as a return which only went to 45(3), and it was then not open to the Revenue to treat that as something other than it was and then amend it. What they should have done was to issue a notice of termination or raise an assessment in relation to the failure to file a 75A return. And if they'd done that, they would have been home and dry.
I mean, you presumably say that a taxpayer who doesn't think there's a notional transaction under 75A, what does he do? Serve another non-transaction return saying he doesn't think so, or just sit tight and wait to be assessed?
He has to sit tight. I mean, this is the other point as to would anybody in their right minds ever file a 75A return? Because if you think you're within 75A, it's because your transactions are unsuccessful and you've done a difficult transaction rather than an easy transaction.
Well, you only file it if you think there really is a notional transaction.
Yeah.
Where in your case is going to be there isn't.
Yeah.
So you do nothing and wait to be assessed.
the most you might do is to write to Birmingham stamp taxes and say, look, these are the transactions we've undertaken. We don't think there is a 75A return obligation here or transaction here, but we're letting you know. Please tell us what you think.
But in any event, there was a DOTAS, wasn't there?
There was a DOTAS.
So the revenue were on notice that...
Oh, yes. I'm sure the DOTAS...
something unusual may have happened.
And I'm sure the DOTAS return, as much as anything else, engendered the consequences that we now find ourselves in. But that's where one is.
Yes, so in effect, it's not a matter of doing nothing if you come within the terms of DOTAS, and I'm not saying that implies anything in particular, but if you come within the terms of DOTAS, you now have to tell the revenue.
And of course, I mean, this is my other point, that the First Year Tribunal thought that the mere fact you had filed a DOTAS return somehow meant that you'd been engaged in something slightly nefarious. Whereas,
No, that's not my point at all.
No, that I appreciate.
Yes.
There was knowledge in the revenue. They did know. They would have been aware of these. And what is more, even after that, there was considerable interchange between the parties as to exactly what the transactions were and why the returns were filed.
I can quite see that of course you're entitled to take the point if it's a good one. As a matter of interest, did it make any difference to you that instead of getting an assessment, you got what you say was an illegitimate amendment of your return?
Well, it does, because it means that this appeal is obviously an appeal against the return and the closure notice, and therefore in those circumstances...
Well, it makes procedural, it sets up the procedural chain. I just wondered whether it made any difference of substance at all.
Well, at the moment, we're fighting against a very substantial tax bill, which has been paid, which we say is too large in any event, which is my next point, the actual consideration point. It would then be for the revenue to start again if they have the enthusiasm. We would say if you start again, it's MAR over there and not us against whom you should be starting, and perhaps you should be raising an assessment on them, not us.
And they're out of time, aren't they now?
Yes, they're out of time for both the determination and the assessment.
No, they say they're still in time to raise an assessment. The problem may be it's paragraph 31.2a of the Schedule 10, which you may have in front of you now because I understand you were given a new document immediately.
Yes, just right.
It's not in there. But paragraph 31A2a gives an extended time limit of 20 years when you haven't actually filed a return.
31A2.
Is it 31.2a?
Quite, pretty close.
It's 31.2 capital A.
31.2.
If you've got, it came in the
Yes.
a few minutes ago.
Yep, 31 brackets 2A,
Yes.
2 capital A.
Yeah.
Yeah, that's the one. 20 years.
Yeah, so you then have to argue about discovery and so on and so forth in the usual sort of way. But that would be a game for a different day.
But which of the 2A criteria would be met?
I'm sorry, I'm just being given a copy myself, but I didn't have.
It'll be B, won't it? Failure to comply with an obligation to file a return.
It is. The revenue rests their case, or will rest their case if they're going to, on 31.2a(b).
And the structure of the tax legislation is such that if they've pinned their claim, just supposing they've pinned their claim to money that they're entitled to and could have done via an assessment, but they've pinned it to the wrong kind of notice, they do have to go back and start all over again, do they?
They do. There was a discussion below as to whether or not the amending provision there's an amending provision in Section 114 of the Taxes Management Act, which has an equivalent in the SDLT code, was such as to enable them to treat an amendment of the wrong return as an amendment of the right return, and the revenue conceded at first-tier tribunal that they wouldn't be in a position to do that.
Well, that's a different question. But I mean, there's a claim for tax, isn't there? That's what these proceedings are originally what?
Well, it's
It's an appeal against the return, isn't it? Yeah. Or against the amendment.
It's an amendment to a land transaction return.
Yeah.
And if the appeal says that no tax is payable because the amendment was defective, then there is no tax to pay.
Yes, I follow.
Yeah, would that be a convenient moment? Or
Well, if you've reached the end of that particular
I have reached
point,
it.
I thought
Yes,
you
I have.
had, yes.
Yes.
And you wish to move on to the human rights point, presumably?
I've got actual consideration, and then I've got human rights. I'm
Yes,
going
you've
to
got
have
about
to
half an
think
hour
about-
left.
Yes, I've got to think how to display those over a shorter journey.
Well, we'll look forward to your attempt at 2 o'clock. We'll adjourn now.